morning, folks. Today we've got a sovereign citizen wannabe who's just practicing trying to get it right, going to court, and according to him, he was forced to take a plea, forced to plead guilty in a civil matter, and he's very upset about it. This is Minnesota Press. Remember the Minnesota Guardian, the guy that got thrown in jail for essay and stuff like that? I don't know if this is him with a new channel because he's not supposed to be on the internet anymore, but it's somebody very similar to him. Let's check out his court trial, which he does sitting in his house over Zoom. Let's check this out, folks. It's very interesting.
We can go number 15, State of Minnesota versus Matthew Eric Zinda.
Counsel could identify himself for the record, please.
Porter, prosecuting attorney for the city of Baxter.
All right, and Mr. Zinda is present, and can you hear us?
I can.
Okay, this is not the Minnesota Guardian. This is a new guy, Minnesota Press. He has a different name. I can't remember what the Minnesota Guardian's name was, but this isn't him.
Good. And this is somewhat different than other matters you may have heard in the fact this is a petty misdemeanor, and so there's no entitlement to a public defender in this matter. But I will ask you if you wish to have time to seek private counsel to help you in this matter, or are you going to continue to represent yourself?
I will continue to represent myself. Thank you, Your Honor.
All right. And Mr. Porter, Mr. Zinda, how would you wish to proceed in that regard?
How would I wish to proceed?
Yes.
I actually had a question for Mr. Porter. Is this a criminal prosecution? I guess I don't understand.
Mr. Zinda, we've had this conversation over and over again prior to this hearing. This matter is now set on for an arraignment. Your Honor, I would request that the court advise Mr. Zinda of his charges, advise him of his rights, and that we get this matter set on for a court trial.
Okay. Mr. Zinda, you are charged with a petty misdemeanor, traffic offense. Because of that, you have a right to a trial, but you have a right to a trial to a judge only. You have the right to confront and cross-examine the witnesses against you. You have the right to bring in your own witnesses. If the witnesses that you want to bring won't cooperate, you can use a court subpoena power to gain their attendance. And if you are wishing to set the matter for trial, we can set the matter for trial. I am aware of the fact that you have filed or have submitted a kind of a laundry list, and it sort of looked to me like it was sort of on the citation and kind of on the back of an envelope, and where you raised a number of things and sent it to a whole lot of people. If you want a trial, we'll set it for trial. If you want to challenge the jurisdiction of the state or make any other challenges, they'll have to be done and a little more formal than on being written on the citation. And a hearing would be held prior to that trial to address those issues. But once those issues were addressed, the matter would go to trial.
I actually, what kind of got skipped over, I guess, is I'm concerned about my right to be informed of the nature and cause of the accusation.
Oh boy, this guy is obviously not very bright. He's trying the sovereign citizen script, but he doesn't know it well enough to be able to jump in there with these comments. So he's just he's stretching now. He's looking, but it's not going to work out for him.
And the nature of the accusation is a failure to stop for a traffic control device. In violation of Minnesota statutes 169.06.5A 3I.
Okay, is it a criminal matter that they're...
Petty misdemeanor is not a crime in the state of Minnesota. It is not punishable by incarceration. No.
I guess that's where I'm confused, Your Honor. I mean, I'm not trying to be difficult. I really am not. I just, if the prosecutor is taking, is criminally prosecuting, I guess I just don't understand how the alleged offense that he is prosecuting is not criminal in nature, and so I guess I don't.
Because the Minnesota legislature made it not criminal. They designated certain violations, particularly traffic violations, as being petty misdemeanors rather than misdemeanors, which are crimes in the state of Minnesota. So if you're looking to find out who did it, the legislature did it.
I would definitely understand if I was being charged with a misdemeanor, that I would be charged with a crime. I'm having difficulty with the petty misdemeanor being prosecuted as a crime.
For the love of God, he just said it wasn't a crime. They voted it down from being a crime to being a petty misdemeanor. It's called due process. They're giving you a break. You either ran a red light or you ran a stop sign. Very simple. I don't know what you don't understand. Maybe you better put the glue down. It's not good for your brain cells.
But it's not being prosecuted as a crime. It's being prosecuted as a petty misdemeanor.
Okay.
And the difference is that you're not entitled to a jury trial. You're not entitled to public defender representation, and you can't be sent to jail. And the maximum fine is capped at, I think they may have raised it to $200, but certainly at one point it was a maximum fine of $100.
It's 300 now. Go ahead.
I just want to make it clear, because the superseding law says in all criminal prosecutions, and I just want to make it clear about whether or not this is a criminal prosecution.
Well, and I've just told you that it's not. And so if you want to bring a motion to dismiss because you think that this is being improperly pursued, you can do that. But what we're going to do is we're going to enter not guilty plea for you. We're going to set the matter for a court trial. You will then have the opportunity to submit a written motion to the court and to Mr. Porter. A date will be set for you to argue that motion. A judge will make a decision on the merits of your motion. If you win, you win. If you lose, you go to trial.
I would just, I'm not trying to stop the court from doing anything. I would just object to a trial because the nature of the alleged offense is not criminal, and
that's why you need to bring your motion. We're not going to argue a motion today.
Okay.
It needs to be in writing. Mr. Porter needs to be aware of the points you're raising, as does the court, and then it will be argued.
Would you be?
But at some point, somebody's going to make a decision, and it might be in your favor, and it might not. But whatever the decision is that the judge who hears it makes, that's going to be it.
Okay. Would you be willing to give me a few days to file that motion before entering not guilty plea on my behalf?
No. We're going to set the matter. We're going to set the matter for a court trial, and that will provide. Then you will have to file your motion prior to that trial to have it heard.
Yeah, nice try, buddy, but it's not gonna work. You're gonna either take a plea or you're gonna move on. It's just ridiculous. He's not trying to delay the trial, though. Certainly not.
Will there be a guarantee that I have a motion hearing prior to? I mean, of course, it depends on my timely filing of the motion. But would it be guaranteed that I would have a motion hearing on that?
I think that it is. If you file a motion, I think the court will schedule a motion hearing, as you say, if it's filed in a timely manner. If you have a trial date on a Wednesday and you file your motion on Tuesday, it's not likely that you're going to get a hearing before the
Sure. That's understandable. Could we, now keeping in mind that I don't consent to a trial, obviously.
Nobody consents to going to court. It's just a fact of life. If you break the law, that's usually where you end up in court. So the judge doesn't care if you consent or you don't consent. And please fix that border around the roof of your apartment there. It looks ridiculous.
But if the court is going to enter a not guilty plea on my behalf, would the court set the trial at as late of a date as possible so that I have time to file the motion and be heard and have the motion heard by a judge prior to the...
I think that I can't tell. I think the clerk can probably tell you when it would be set. I can tell you that the dates where they have been setting these things for, or have been setting matters off this calendar for, that have been pre-trials, and I suspect court trials as well, have been in late February, early March.
Okay, and one other question. Is there a way to compel Mr. Kurt Porter to provide any kind of evidence of personal jurisdiction? Would I be able to do that?
Mr. Porter will provide discovery to you.
Okay. Yeah, I'm not really happy about it, but if the court is entering a not guilty plea on my behalf, I am objecting to that. However, that's about all I can do is object to entering a not guilty plea on my behalf, and
your objection is noted. I would remind you, however, that the alternative to a not guilty plea is a guilty plea. So I think that a not guilty plea is probably more protective of your rights than saying, well, you need to just plead guilty. So we'll just leave it with a not guilty plea, a court trial.
Well,
and if you want to file a motion, you certainly are entitled to do that.
Okay, now, Your Honor, the only reason I'm having problems with that is because it basically grants the attorney personal jurisdiction before any evidence of personal jurisdiction is presented.
Well, Mr. Zinda, I would argue in the alternative that you have already subjected yourself to the court's personal jurisdiction by appearing. And so if you want to argue that the court does not have jurisdiction, that would be part of your motion.
Like I said, you really need to put that glue down, stop sniffing it. That way maybe you could afford to fix your trim around your ceiling there back on the wall where it belongs. That must be where the glue went, up your nose, because you're just not getting it.
The courts, I'm not arguing that the court doesn't have jurisdiction. I'm arguing that the attorney, the attorney at law, Kurt Porter, is lacking personal jurisdiction.
He doesn't have to have personal jurisdiction. The court has to have personal jurisdiction, and the jurisdiction of the law enforcement agency that issues the citation might be at issue. But Mr. Porter himself personally does not have to have any sort of jurisdiction. So let's just set a trial date. And then you can file your motion and you can raise your jurisdictional arguments. And Mr. Porter will have your motion to know how to respond, and the court will have your motion to know where things are going, and we'll see how it goes.
Okay, and the objection to and the entering of the not guilty plea at the court's will is noted, correct, sir?
It certainly is noted. There's been a record made, and if you wanted a transcript of this, you could contact the court reporter, and she'd tell you how to buy one. I
can think of one other important issue. Before we call this a day, if you don't mind. The only other issue is that my name is actually spelled with just one capital letter at the beginning of each surname, and the rest of the name, it's capital M, lowercase a, T, T, H, E, W. I don't like the all capital letters on there, and so the spelling of my name contains lowercase letters, and that's all I would like noted.
Okay.
And again, the judge doesn't care how your name is spelt with capital letters or small letters. It's a tactic, quantum grammar tactic that sovereign citizens use that has failed every single time they've tried it.
That will be duly noted.
Okay.
What sort of a date can we give Mr. Zinder?
We're looking at February 8th at 1:30.
Mr. Zinda, is that enough time?
Well, I don't think it's enough time, but I just don't. I mean,
Well, let's ask, can we go out and say another 2 or 3 weeks?
I mean, I guess with all due respect, Your Honor, I've objected to the not guilty plea, and so I guess whenever it pleases the court to schedule the.
Okay, well, I just asked the clerk if we could go out another 3 weeks.
Okay.
We can do the 22nd of February at 1:30.
That's about 60 days, so.
Okay, while he's on long pause because he can't think of anything to say, I'm going to go ahead and accept that date. Thank you.
I'll have no other option than to object to the not guilty plea and defend myself at all future hearings that the court might schedule. You know.
Okay. All right. So, but you have a trial date. When the motion is depends on when you make your filing.
I will get it done as soon as possible.
And you have to bear in mind that not only do you have to file it with the court, you have to send a copy of everything to Mr. Porter.
And Your Honor, before we go off the record on this matter, I would note that our office sent discovery on November 6th, including papers.
And Mr. Zinda, did you get that information?
I did. I'd also like it noted that I have been asking Mr. Porter about the nature of this matter for since I requested the discovery. And so I'd just like that noted as well.
Okay. Thank you, Your Honor. Okay. All right. That will conclude the appearance, Mr. Zinda, and you're free to log off.
Thank you, sir.
And that was the pre-trial of Mr. Zinda. This was 8 months ago. He never, ever made another video about this court appearance, so I'm going to have to assume that he was found guilty and paid a $200 fine, since that's what the fine is for running a traffic device. So, nice try there, Matthew, but it didn't work out for you, I'm sure. Anyway, that's all I got for you today. Just something a little different. Y'all have a great day. Love ya. Bye.